The speakers will each present on the topic of reproductive justice. Then I may pose some questions to them. Finally, we will take questions from the audience. Those of you here in person will speak into the microphone, I think at that table. And those of you Zooming in should type your questions in the question and answer panel. Tonight, we're privileged to hear from Karrie Galloway and Professor Leslie Francis. Karrie Galloway is the Executive Director and CEO of the Planned Parenthood Association of Utah. She joined Planned Parenthood Association of Utah in 1981 as a community educator. As the oldest child in a, quote, good Catholic family in Wisconsin, she grew up believing that families are important and the decision to have kids is important. Over time, she became the associate director of PPAU and in 1987 became the leader of the organization. She says she will be retiring at the end of this calendar year, but I now know she will not be retiring until a new director is on board, hopefully before March. So she's going to hang in there a little bit longer. PPAU provides high quality, inclusive, and comprehensive sexual and reproductive health care services to all people with respect and compassion. This includes education, contraception, and STD testing services, in addition to abortion care. PPAU also engages in advocacy work regarding reproductive health care, including legislative advocacy and litigation. In 2020, Karrie Galloway received the Kristen Rice Community Service Award from the Utah Pride Center, which noted that PPAU served over 11,500 teens and families annually with medically accurate, responsible sex education, trained current and future educators about how to make classrooms safe for LGBTQ students, and provided STD testing to the LGBTQ community. In 2022, she received the Fairly Free Thinker Award from the First Unitarian Church of Salt Lake City. And I'm sure before she retires, she will get some more awards, just piling up. Our other speaker tonight is Professor Leslie P. Francis, who holds a Ph.D. and a J.D. She's the Distinguished Professor of Philosophy and Law, as well as Alfred C. Emery Professor of Law at the University of Utah. She holds adjunct appointments in Family and Preventive Medicine in the Division of Public Health, Internal Medicine in the Division of Medical Ethics, and Political Science. She was initial director of the University of Utah's Center for Law and Biomedical Sciences from 2015 to 2022. She is a past member of the Ethics Committee of the American Society for Reproductive Medicine. Her research and teaching specialties are in the area of bioethics and medical ethics. Professor Francis's books include Sustaining Surveillance, The Importance of Information for Public Health, co-authored with John Francis, 2021. The Patient as Victim and Vector, Ethics and Infectious Diseases, co-authored with Batten, Jacobson, and Smith, 2010. And Privacy, What Everyone Needs to Know, co-authored with John Francis, 2017. She edited the Oxford Handbook of Reproductive Ethics, published in 2017, and is the author of many papers in the areas of disability law and ethics, privacy and data use, justice, and bioethics. So I hope you all are as excited to hear from our panelists as I am. We now need them to turn on their microphones before they're allowed to talk.
Thank you so much, and I'm excited to be here. I'm not sure we've got how do we get my slides ready to roll?
I do that. Where do I do
Okay, so let me just say before we get started that I'm really, when I think about reproductive justice, I'm going to steal this from the reproductive justice movement, which started as a movement of Black women emphasizing three things: the right to have the children you want, the right to not have the children you don't want to have, and the right to be able to raise your children in a safe and healthy environment, which is a way of reframing the discussion to be about justice. I'm going to be doing legal background, and I'm going to turn it over to the practical on the ground. How do we achieve justice? after I do the legal table setting, because I think there's a lot to know about where we've come from, where we are right now, and where we might go. So let me launch in. And I should say, anytime I say something that's unclear or that you want to challenge or that you want me to say more about, um, please just interrupt me. And I can't see people online. So the way this is set up, so I'll have to rely on other folks. Okay. So, first thing to just know is that Dobbs is about federal constitutional law. It's not about state law, except insofar as the federal constitution limits what states can do. So the piece of the Constitution that has been central all the way along, from cases about mandatory sterilization to cases about whether you could educate your children in languages other than English, to contraception, and to same sex marriage, has been the Due Process Clause of the 14th Amendment, which prohibits states from depriving any person of life, liberty, or property without due process of law. That's the straight on language. Everybody agrees that includes legal process, like whether you have a right to a hearing before your liberty can be taken away. But does it go beyond just process to substantive liberties? And over the course of the last century, the Supreme Court has been incorporating substantive protected liberties into the understanding of liberty of the Due Process Clause, going beyond just process. Justice Thomas would throw all of that out, but so far he's the only one announcing that position. So freedom of speech, freedom of religion, those have all been understood to be the liberty in the 14th Amendment. What happened in Griswold versus Connecticut was that a state prohibition on the use of contraceptives was held to be a violation of due process liberty, understood as a kind of privacy in intimate relationships. So that's a little bit of initial background to even Roe. Now, to say that we've got a fundamental liberty protected by the Due Process Clause doesn't mean it's absolute. It just means that if the state is going to have if the state's going to limit it, it has to have a compelling interest and do it in a very carefully, narrowly tailored way. Okay. So I've already told you about Griswold using the language of privacy. That's in 1965, about the time contraceptives were actually coming into wider use. It's Griswold versus Connecticut. I mean, it was Connecticut that had the prohibition on the use of contraceptives. So then we get Roe in 1973, relying on Griswold and saying that there is a constitutional right to privacy that encompasses the intimate decision whether or not to continue a pregnancy. Roe also used the trimester framework to think about when and which state interests might become compelling. So, for example, third trimester, a state interest in protecting potential life could be thought of as becoming compelling. Uh, in 1993, the court heard the first case in which people thought it was possibly realistic to think that the court would overrule Roe. This is Planned Parenthood of Southeastern Pennsylvania versus Casey, the governor of Pennsylvania, I think. What Casey did was reaffirm the central Roe right, the right to decide, but it reframed it entirely. Privacy's not in the way Casey thought about things. It's liberty now. The liberty to make particularly important and intimate choices. That switch was actually presaged by a case probably you all haven't heard of very, very much, the case of a young woman in a persistent vegetative state, Nancy Cruzan, whose parents wanted to discontinue medical treatment. And the court in Cruzan said, we'll assume for the sake of the argument that there's a liberty right to refuse medical treatment. And so the state needs to have a compelling interest if it's going to restrict that. And then the court went on to say, and Missouri has a right at least to make super duper sure that this is what Nancy Cruzan would have wanted or in her interest. So it's actually the Cruzan case that shifted the language from privacy to liberty. So anytime the court or people talk about privacy's not in the Constitution, they really need to be thinking about liberty and how we understand it, because strictly speaking, what's going on in Dobbs is whether Casey should be, whether the Roe right reinterpreted through Casey should be overruled. Casey also completely dropped the trimester framework and basically said all along in pregnancy can impose an undue burden. And then, we had a whole litany of cases looking at what's an undue burden, which I am sure you all have been dealing with for a long time, since 1993, right? Roughly, just about 30 years. I got my math right. And then, we have the same-sex marriage case, Obergefell. Again, a liberty, intimate liberty case. So here's what the court did say in Dobbs and what it didn't say, okay? So it said the Roe right is gone. No liberty right to choose whether or not to continue a pregnancy. What that means is if the state's going to regulate now, all it's got to have is a rational basis for doing it. And that's about as easy as any old piece of lint you might pick up on a legislative floor. I mean, the rational basis test is, even if it's not a good legislative reason, as long as there's sort of something there. So it's pretty easy to meet. But Dobbs only says the Roe right is gone. The justices were explicit that they didn't mean to take away other rights. In particular, that they didn't mean to say anything about same-sex marriage or about contraception. The dissent said, we'll see on that, because your reasoning is if you're throwing away a lot of substantive rights, how are you going to distinguish these other cases? Justice Alito's answer was, well, they didn't involve a fetus, but we're going to see what level of whether that stands up. But here's some things that weren't mentioned at all. We've still got the Fourth Amendment, protection against unreasonable searches and seizures. Dobbs doesn't say anything about that. So, looking at people's files and medical records, well, doesn't say anything about freedom of expression. So there's going to be litigation about what doctors can say to their patients or what other people can say. Dobbs doesn't say anything about that. And then there's this long recognized constitutional right to travel. The majority opinion didn't mention it. Justice Kavanaugh, in concurrence, explicitly said that he joined the majority opinion, but he did not read it to affect the right to travel. So that would mean, how far is West Wendover? It's 110 miles. That's not a very long drive. I mean, there are some states where it would be a very long drive. But if Justice Kavanaugh is to be believed, he would not uphold a law that infringed on somebody's right to drive to West Wendover, pick up medication abortion, and enjoy an evening at a casino, say, whatever you might want to do. So that's a lot of stuff that Dobbs just didn't even touch. There are a lot of other laws that Dobbs also doesn't touch. So there's federal statutory law that if a hospital takes Medicare, they've got to provide appropriate emergency treatment. And there's the case in Idaho where Idaho's very draconian law has been curtailed by the EMTALA obligation. And it doesn't touch state laws at all, including state, except insofar as they run afoul of the 14th Amendment. Well, a state that's more protective of liberty isn't going to run afoul of the 14th Amendment. It's doing more than the 14th Amendment. So it's an open constitutional question, which voters resolved in Kansas, but it'll also be true here in Utah, depending on what the Utah Supreme Court decides to do. Okay, so just a little bit about what we've got here now. We do have a statute that does define abortion to only involve activity after implantation. So anybody who's worried about in vitro fertilization, frozen embryos, probably doesn't. I mean, there's some iffy questions about it, but you probably don't have to worry about fertility treatment, except insofar as it might generate a multiple pregnancy, and then there would be a medical question of selective abortion reduction, making sure you don't carry triplets because all three of them might die kind of situation. Utah also explicitly has an exception for ectopic pregnancies. And so they may not be perfectly diagnosable, so that could be a problem, but there are a couple of things that people have been super duper worried about, that whatever happens here so far anyway. So here's what we've got right now. In effect is the prohibition on abortion where the sole reason would be Down syndrome. I don't know that anybody ever has a single reason when they make a hard decision like this, but if it were the case that that was true. And the 18-week ban is currently not enjoined, but the trigger law is currently on hold. And The 18-week ban does have some exceptions. If abortion is needed to protect the woman's life, if abortion is needed to prevent serious risk of substantial and irreversible impairment of a major bodily function of the woman, if two maternal fetal physicians certify in writing that there's a fetal defect that is uniformly diagnosable and uniformly lethal, whatever that means, um, or a severe brain or abnormality that's universally diagnosable, which would, in essence, mean that the fetus would never be conscious, and rape or incest with appropriate reporting. So those are the exceptions, and they would be carried over into the trigger law. So I've set the legal table, and I'm now going to turn it over to the expert about whether it's currently feast or famine under that table. And
Thank you, Leslie. I have to say, I always appreciate sharing the table with Leslie because she grounds me. I'm a gal of the 60s. I can get kind of passionate about good sex. And so, grounding in law and what our limits and parameters are is very important for me when talking about a topic I am emotionally as well as professionally invested in. And so I appreciate how clearly she sets the table in reminding us how we got here. Um, I was at a conference this week that's put out by the um, National Reproductive Health Association, National Family Planning and Reproductive Health Association, that a high holiday for them is the Griswold decision. We always celebrate it in style. We raise a glass, have fancy poopahs, and, really enjoy the fact that it was one of the first public cases that recognized the importance of family planning, the importance of building strong families needs some planning, and contraception does that. And we're lucky that we have the science that moved in that direction to have ways of practicing family planning other than counting days or pulling out or hope is not a method. One of those things that probably we all practiced once or twice. Um, and it is, I, I, as Leslie, struggle sometime with reproductive justice because it is a concept that was developed by Black women, a group called Sister Song, who knew that to build strong families, they needed the help of systems because you had to be able to raise a family if you created one. And Black families struggle in this world to have parity with opportunity. And so I sometimes shy away from co-opting the work that they have done. But family planning, reproductive health care, access to reproductive health care, not only physical access, mental access, but financial access is what Planned Parenthood is based on. And where we're at today from the history that Leslie has given us is, for those of you who have followed Planned Parenthood, one thing since we started in Utah in the early 70s that we have never shied away from is to challenge through the court system when things are done wrong about reproductive health care, reproductive access, or reproductive justice. And leading up to this trigger ban, which was passed a couple of years before Dobbs, during a legislative session that wasn't going well for those who like to control women's bodies, they decided that they probably needed to have something in their back pocket in case some state was more creative than Utah and got to the Supreme Court first, and maybe things opened up for them to control us. I say that because you all appear to be women. And so they passed fairly capriciously, I would say, a trigger ban that meant if any court higher than what was in Utah allowed them to control our bodily autonomy, they would do that. And so they didn't fill in the rules around the trigger ban other than to say the usual. And so we knew as Planned Parenthood that we had to be ready for that. We were already in court on the 18-week ban because when they passed the 18-week ban, it was before viability. And therefore we challenged it, got an injunction, and kept it from going into effect. Unfortunately, through the legal system, no offense meant to your JD, but through the legal system, we had the injunction on the 18-week case, but it was stopped twice while they waited for the Supreme Court to rule on other possible cases. Nothing moves quick in these cases. And so we were at a place waiting for the Dobbs ruling, and then Dobbs dropped. And we, as Planned Parenthood of Utah, can only manage one case at a time. So we had to let the 18-week case go to fight the trigger ban. And so even though Dobbs was decided and announced early in the day on the 24th of June, we had been working for probably a year in how we could address here in Utah the trigger ban. And I have to say, Planned Parenthood has attorneys that are some of the smartest people in the world, and reproductive freedom is what they major in. And our lawyer, Julie Murray, in reading the Utah Constitution, because our Constitution was late to the game. Utah was a later state. And the predominant people who settled Utah were those of the Church of Jesus Christ of Latter-day Saints. And at that point in their theology and practice of religion, women had more respect and power in many of the dealings with families than sometimes they are recognized for now. And so when they wrote the Utah Constitution, they said that no law could, I'm not using the right words, but no law could disadvantage a man over a woman or a woman over a man in how the law was written. They couldn't disadvantage one over the other. They were equal. In this case, taking away a woman or a person who can get pregnant bodily autonomy, we have said, is a disadvantage for women. and people who can get pregnant. And then we have we have 6 points to the case. And I think I have to congratulate the Tribune at this point, because as we filed our lawsuit, they have allowed the public to follow along by printing the papers for this lawsuit and by broadcasting so that people could listen to the hearings. And we were fortunate. It dropped on the 24th in the morning. By 6 o'clock that evening, while we were preparing for a rally at the Capitol, we had word that the legislative, um, what are they called? The group that are the lawyers for the legislature had determined that the trigger law could go into effect. And so by 6 o'clock that night, it went into effect. By Saturday evening, we had dropped our lawsuit. All the papers were signed, and we dropped our lawsuit. On Monday morning, we learned that the first judge who had been assigned to the case recused themselves. We never knew why, but Judge Stone was assigned to the case. And Monday afternoon, the first injunction hearing was held. The state basics case, and I will be irreverent here, but it's what I believe is that they could do it and they did it. And so if you don't like it, elect different legislators. That was pretty much their case, as I heard it. Our case was that you can't take away bodily autonomy from women to make their own healthcare decisions, and for all the reasons that pregnancy doesn't come without risks for women. So you're forcing them to take a risk, whether they choose to or not. And I thought our lawyers were brilliant and made the case. And luckily, Judge Stone thought that they did a good job too. And he did the first injunction. That lasts 2 weeks. And then both the state and Planned Parenthood exchanged their papers with the judge. And then we had another hearing. And again, he granted a preliminary injunction, which that one holds until the case is heard in state court. And our hearing date is September 2023. So we knew that the state would not take that at face value and that they would appeal. Now, they had a certain time that they could appeal the case, and they appealed it at the very end of that time period. So they could not say that it was an emergency, that the state was harmed and that they needed to lift the injunction, but they asked the state Supreme Court to lift the injunction, and to hear their pleadings for why there should not be an injunction and why the trigger law should go into effect. The state Supreme Court said they would hear their plea, but they were not lifting the injunction. The other issue that the state has brought into the case, and it is an issue that comes up a lot when a group like Planned Parenthood or the ACLU sues on behalf of other people. We sue on behalf of our clients who come to us for health care. And because this law keeps us from providing that health care. It was the other issue that the state rose, that Planned Parenthood should not be able to sue on behalf of these women. They should put their case forward themselves. And they really were strong on that. One of the times that our 18-week case was on pause was for a case that the Supreme Court was deciding out of Texas, that dealt with standing. Standing is for Planned Parenthood to sue on behalf of other people. That case was decided for us, though we weren't the plaintiff in that case, but for this method of suing on behalf of other people. So Judge Stone said, and I loved it, that when a woman's looking for health care, she doesn't go and find a lawyer. She comes to Planned Parenthood. I thought, yeah, you're right. So they ruled that we were the correct people. And I have to tell you, we were not asking women to tell their story. Planned Parenthood takes very seriously that women should not be having to tell the public why they need health care. We would like to protect people's HIPAA, you know? But before that hearing, after the 2 weeks for the preliminary injunction, we decided we really had to get serious here. And we had the lawyers waiting in one room, and then our staff would say to a woman when she came in for her informed consent, which is the state mandated information that you need to have 72 hours before you can make an appointment for an abortion, because they don't trust that you really know that you're making the right decision. So you have to get state mandated information and then wait 72 hours before you can make an appointment for an abortion. We spoke to these women and said, would you be willing to tell your story? And we had 3 or 4 very good stories, mostly because women don't know lawyers who come to Planned Parenthood for healthcare. They wouldn't know who to talk to. They can't take time off of work or school to talk to lawyers. They don't have money to talk to lawyers, and they don't want to talk to lawyers. They want to talk to healthcare. And for some of them, they didn't want other people knowing that they were coming for an abortion. And the stories were very compelling because everybody's story is theirs. It's their reason for making this decision. And that it turned out to be a very compelling part of our argument for the preliminary injunction. So I have to say, we've been through this process many times. As I've been with Planned Parenthood, we've had to sue about Title X. We've had to sue about abortion. We had to sue one time when the legislature made a law that minors couldn't buy condoms in grocery stores without their parents' permission. That was a fascinating summer as we went through that one. But so we were ready when the state asked, appealed our injunction. What is so hard about it is every time it makes the news, it it never comes through clearly for everyone that abortion is still legal in Utah. And people worry that they can get health care. Think of yourself as someone who comes to Planned Parenthood. Number one, usually you don't have insurance. You're not used to working the system. You are going for something that the world has made you feel shameful about. You have to worry whether someone's going to tell on you or cause trouble. And now they talk about jail and all of that sort of stuff. When you are dealing with a problem or an unwanted or a mistaken pregnancy, and you know you've got to do something because you just can't be pregnant and raise a child at this particular time. To hear something on the radio that they've sued and blah, 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 blah. Oh, I just feel for all of those women or pregnant people who are trying to work through their problems. And that's why Planned Parenthood does this in the name of other people, because we know lawyers, we know how to talk to them, and it's not our first rodeo. And damn it, we're going to stand up for them. And so it's where we're at right now. Um, when people come for healthcare, especially during trying times, they're not always on their best behavior. And I have to say, they're stressed. And the other group that's stressed is my staff. We have providers who spend their lives going through medical school and practicing healthcare to make other people's lives better for them. And they have to worry about going to jail. They have to worry about losing their medical license. And if they have a partner, that partner worries about the loss of income for that family. It's the first time Planned Parenthood has ever had to hire criminal lawyers who now help us talk to our staff, know where people can intervene. We don't have a citizen action here in Utah with our trigger ban, but we've heard about what's happened in Texas, where anybody can tell on it and take someone to court for getting an abortion or performing an abortion or driving the lift car to the abortion and get $10,000 if it works. Now, nothing's happened, but they have specifically allowed that. It's all out there in the talk, in um the what is Twitter sphere, all of that sort of stuff. People who don't like abortion saying, I'm coming for you. We have people out in front of our health centers with their cameras on their chests and their little megaphones talking about how bad the people are coming to our health center. Do they want to go to hell? Do they, all of this stuff. We have fights of partners of people coming in for health care. It's a mess. And it's all because people who are in elected positions have decided they know better for people how they should live their lives. And that's the part that drives me crazy. They aren't in these people's lives, but they feel like they know better. Um, and it's always the women who end up being punished. The fact that the sperm didn't come from them, it came from a male, but they don't have any culpability in this whole discussion. And that's the 60s activist in me, that this isn't a fair fight at all. So no matter what, Planned Parenthood will stand up for the people needing health care. I often joke that the reason I do this is because I believe in good sex, happy sex, responsible sex, consensual sex, but responsible sex. And it is so frustrating when the entire burden falls to the pregnant person and they're making the decisions for that pregnant person. Some good news. I digress. And so I'm going to go for some good news. Before we came, Leslie and I were talking about last Tuesday. Things maybe didn't go as well as we wanted here in Utah. Maybe your people didn't get in. But when we look at this issue of reproductive freedom, reproductive health care, and reproductive justice, the people won. Because from all the polling, we know that the people did not want the fall of Roe. There's a varying degree of what hoops they feel people should jump through, but people did not want the decision taken away from women, people who get pregnant, families, and their healthcare provider. And so now we have Michigan, California, Montana, Kentucky, and Vermont, all last Tuesday. The peoples won. And as Leslie mentioned, we had Kansas in the summer. And I know from being part of this world, there are a lot of other states lined up to clarify what's happening. Leslie brought up West Wendover. We here in Utah, even though we have an injunction that's holding strong right now, we are living with people who come to Utah from Idaho. We can no longer serve people from Idaho for pregnancy termination or abortion in our Logan clinic because our Logan clinic only does medication abortion, and we cannot have our providers giving women who live in Idaho a prescription to terminate a pregnancy because we can't force her to stay in Utah to take the pills. If she goes home to Idaho and completes the abortion there on the second day, there is the potential that she has broken Idaho law and they could come after Utah providers. So for the people from Idaho that we see, they will have to come to Salt Lake for a surgical termination. We, of course, are worried about people from Utah when this whole thing is decided, hopefully years from now, and we'll have sorted out a few things. But we have Nevada and Colorado on either side of this. Colorado has worked for years to enshrine reproductive freedom in Colorado. If you have followed their politics for the last 10 years, they have probably seen the people, what do they call that we don't do here? When we do them, the legislature changes them. Referendums. They have done referendums against abortion in Colorado every year for years, and they have all failed. And they have enshrined reproductive freedom into Colorado's way of doing things. Nevada has been much more passive, but it is enshrined in what they've got. They're starting to whittle away at it now. And as Leslie pointed out, West Wendover is only 110 miles away. We are working with our sister Planned Parenthood, who covers northern Nevada, about whether we're going to be able to provide health care in West Wendover. And I received information yesterday they have purchased property. So things are looking up. I mean, it'll take a while to build. It'll take a while to solve this lawsuit. Lori? Yeah.
And they were very patient. They waited a long time. They waited half a century.
Mhm.
I don't feel like we were at the top of our game.
We relied on the courts. We have relied on the courts. And as Leslie pointed out to us, they've become unreliable.
So what's our game plan for the next 50 years?
We also forgot about state governments.
We forgot about legislators who want to control money.
Right. Well, I mean, state legislatures, and I mean, that's partly why I pointed out the realm of state law that's potentially there. But
Lori, we're going to have to, and all of us, we're going to have to gird our loins, as they say, and start fighting. Within the Planned Parenthood world, we're looking at a lot of things because we've got 50 states that we're trying to protect in one way or another, and we're having to start from scratch now. But one thing that's different than it was 50 years ago is science is different. Women are different. We're not putting up with this crap. You know, we're not going to jail, but we're going to figure out ways to deal with it. Medication abortion is safe. The scientists are doing their number crunching. The data people are doing that. They're looking at all of the science to be able to counteract those who will say they're doing this for women's health, because they're not. We will have to rely on safe states, but that leaves out women without financial means, emotional means, educational means to travel. I've heard that 50% of the people haven't ventured out of the county they were born in. Not everybody travels. And so Kavanaugh saying that you can go to West Wendover doesn't work for a lot of the people. And so life is hard and it's not fair. And for those of us like the League of Women Voters who work for fairness, we have to join together and keep working. You know, we can't retire from the world. We've got to keep working. And each of us doing our part in standing up for people who can get pregnant.
Let me ask the audience to join me in thanking our panelists. Before we move to the question and answer, we're not going to get this applause if we just moved right to the question and answer. I have a question online. But before I ask the question online, just to clarify, this is about the Utah case. The Utah case has 6 theories about why it may be unconstitutional to prohibit abortion in Utah. The one you talked about was under our Equal Rights Amendment, but there's the uniform operation of the laws, which is a lot like the Equal Rights Amendment, the right to bodily integrity, the right to determine one's own family composition, the right of conscience, which is sort of first, like the US First Amendment, religious liberty, and the right of privacy. So those are the 6 theories that the lawyers are advancing. I have a question online. How effective do you think the challenge based on the religious liberty theory would be? And this is to both of you. And which of these theories do the lawyers think might be most possible under the Utah Constitution?
Go ahead.
Well, I'm going to say, honestly, I don't know. I mean, if I were the lawyers, which I'm not, I would be arguing every single one of them, and hope that in numbers there is strength, because there are lots of, as Linda pointed out, there are 6. I would also be pointing out how different the Utah Constitution is in all of these respects, and that those differences, if you want to appeal to judges who are more of a kind of originalist bent, that these differences are deeply rooted in the history of this state. They're not like something new. So we'll see. I mean, you may have talked directly to your lawyers. Linda, you may know more about that. You're working on a brief, I think, aren't you? So, you might have something you could say too.
The rights of conscience, there's our paragraph on religious liberties is the largest paragraph on religious liberty in any state's constitution, and it's way bigger than the federal constitution. The right of conscience shall never be denied. What does that mean? It's very open. If you look at the Constitutional Convention, they clearly meant it broader than just religious practices, because they meant it to apply to atheists as well. And atheists don't have a lot of religious practices. So what does that mean, the right of conscience? And then there's another line that says no religious denomination shall dominate the state. And so many people think perhaps our laws are from time to time the result of a religious domination dominating the state as they dominate the state legislature. So that's something that isn't in any other state constitution. So what they'll make of that. Our Equal Rights Amendment is more robust than the federal Equal Rights Amendment that's never been passed. So as Karrie was saying, women and this is 1895, I think, when our Constitution was passed, women were very independent there, often because they were polygamous wives living alone in this farm or that farm, and they had to be independent. And so that the Equal Rights Amendment needs to be understood in light of what was going on in Utah at the time. So it'll be very interesting and curious to see what the Utah Supreme Court makes of these Utah constitutional arguments. We have a question in the front row. Can you come up to this microphone so that the people on Zoom will hear you? Because if you just ask it from the audience, we hear you, but the Zoomers might not.
What is the status of the Texas bounty law?
It's there.
I mean, I know it's been challenged. Is it working its way through the courts, or?
I think it's in effect, isn't it?
It's in effect.
Yeah.
And in Texas, because of the circuit that they're in, nothing makes it beyond Texas. It's dismal. It really hasn't been challenged, I would say.
Yeah, it's there. And I just yesterday, I had a physician from Texas log into the class that I'm teaching about abortion. And I'm going to use this as an example. So I think one of the things a group like this can do is make it very clear that this is not just that the impact of these anti-abortion laws, like the Texas bounty hunter one, is not just about women's reproductive care. it's also about women's health care more generally. So 1 in 1,000 women who are pregnant every year are diagnosed with cancer. That might sound surprisingly high to people. Part of it is that this is often the first time women have seen a doctor in a long time, so they may have undiagnosed conditions. Part of it is that some cancers are fueled by the hormones that you have in pregnancy. And oncology care in Texas is being affected because the choice now is basically how long do you put your chemo or radiation treatment on hold, until you can deliver. So, or, maybe you leave Texas, but, um, and don't come back at the wrong time. But I think, the more it's known that this isn't just about a narrow slice of healthcare. This is about lots of healthcare. And it's also about women with disabilities being able to have safe pregnancies. They might not be able to carry a multiple, say, but they might be able to carry a singleton pregnancy. Uh, it's really much. So we need to get the whole medical profession on board. Every single major medical organization has condemned the Dobbs decision, but and there is even something a little bit from last year's Utah Medical Association. So, the more just the widespread impact of this can be known, the more then you get an understanding of what inequality might really be involved if a law like an abortion ban from the moment of implantation went into effect. But yeah, Texas is
Yeah, no,
a difficult place right now.
I just find it astounding that it's not working its way through the courts.
The reason, the theory that the people had that passed the law was Planned Parenthood or other agencies couldn't sue the state for an unconstitutional law because the state was not going to be enforcing
Right,
this law.
right.
It was going to be private, bounty hunters. And so that apparently has held true based on the way the courts have interpreted what they're allowed to
Right.
do. And so I don't think very many or any people have been successful as bounty hunters in suing people that have performed abortions or gotten abortions. And so there's not been any court decision against one of these providers. And so nobody's been able to appeal it. Now, I don't know
On the
whether
other
there are
hand, it's
groups looking for ways to attack it, but I think it's having an impact by preventing medical providers from doing what they think is the right thing.
Yeah, it's massively affected
Right.
healthcare practice in Texas. I was just at a meeting of the American Society for Bioethics and Humanities where people were talking about cancer care during pregnancy, and different folks from different states were talking about how that's been affected. Another thing that's going to be affected, which I think will, this is the sort of thing that state legislators need to be aware of. So, a lot of the really good medical care that people get, say in the cancer area, they get in clinical trials, testing, is it a little bit better or so on. Well, um, some clinical trials are no longer going to be in states with draconian anti-abortion laws. So if you're thinking about, do you want to have the fanciest cancer center in the Intermountain West in our state? You got to think about those questions. I mean, maybe you resolve it. I'm not going to take a political position about that, but I'm saying that's something that is going to be on the table. One of the reasons I mentioned the fact that at least our statute doesn't, or if it does go into, our statute doesn't define abortion as pre implantation. That, there are a lot of people in this state who are using IVF to get pregnant. And there are some states, Louisiana, for example, where IVF clinics have just shut down.
And also, I read that medical education
Oh, yeah.
itself is being drastically
Well,
affected.
so the family planning program here now has to make arrangements for residents and fellows to get training elsewhere um, on techniques that are actually critical to good miscarriage care also. And that's true of all the major residency programs in Texas. I heard that yesterday. Another thing that I heard at ASBH is that residency programs in a lot of fields of medicine, not so this is just anecdotal, I don't have um, comprehensive data on this, but residency programs in states where significant bans are in effect are having a drop in applicants, and residency programs in states where um, abortion rights are protected, massive increase in applications. So, if you're worried about the quality, the word needs to get out that if you're worried about the quality of medical care, you want to worry about these issues.
Other questions? I can come up with some. Karrie mentioned the 5 states in which there were referenda on constitutional questions about abortion. And some of the states were, um, should we be allowed to make a law that prohibits abortion? And some of the questions were, should abortion be, taken out of our Constitution? And in each instance, no matter what the question was, the pro-choice people won. What other states are pursuing litigation like we are? I know like Ohio has an abortion ban that's currently in litigation. I think North Carolina. How many?
There are a bunch on hold.
Even Wyoming. Oh. Even Wyoming. And I loved Wyoming because I have a perverse sense of humor. Wyoming, the cowboy state, the independent state, changed their constitution during the whole Obamacare discussion because they wanted their constitution to say that each person got to make their own healthcare decisions. So they changed their constitution that men and women could make their own healthcare decisions. And there is a delightful private provider in Wyoming, in Jackson Hole, who's a feminist. And when it happened, she got, I think, the NARAL group. I can't remember which feminist group is helping her. She doesn't have a Planned Parenthood. She doesn't have any real national behind her, but she sued the state of Wyoming for when they wanted to eliminate abortion. She only provides first trimester medication abortion, but she wasn't going to let it stand. And the legislator said, "Oh, well, we didn't mean for abortion." Well, yeah, should have put it into the Constitution then. But so they have a constitutional um, uh, challenge also in Wyoming. And I just love that story.
There's some other issues that, I know this is a group that's interested in politics and in issues. And just 2 others that I would put on your radar screen. One of them is, and I'll just sort of do this nationally. One of them is access to free contraception, because prevention really helps. And so, uh, and related to that, really good access to healthcare for everybody. I'd put a little bit of good sex ed on your radar screen. And the last thing, which isn't so relevant in Utah, but is relevant in some other states, there's it's not quite perfect, but there's a really impressive correlation between how strict your anti-abortion law is, whether or not you've expanded state Medicaid, and something else that people might not have thought of, whether you license independent practice nurse practitioners and nurse midwives. A lot of states that have not expanded Medicaid and that are among the leaders in restricting abortion don't permit nurses to practice except in an agreement with doctors, which significantly reduces availability of healthcare to parts of the population. I mean, for one thing, it costs less to see an independent practice nurse. So we do license independent practice nurses and nurse midwives in Utah, but we've also expanded Medicaid. So, it's the trifecta that there are about 5 or 6 states that look like that. It's pretty impressive.
Lori, do you want to come up to the mic?
So Karrie knows this. I've been a volunteer. In
Make sure the mic is on, because I think the other one's on. The other one's on. Hit the button. Either way, make it light green.
I've been a volunteer with Karrie. I've known Karrie for 40 years, literally since I was a teenager. One of the things that Karrie taught me, and I think it's so critical now more than any other time, is if people understand sex education, if they know how their bodies work, if they know how to use contraception properly, where are we in the discussion of if you don't want abortion, then why don't we educate people so they know how their bodies work? And why don't we make contraception readily available? If you did those two things, imagine the decrease nationwide in abortion. But we want people to be dumb and we don't want to give them access. You can't have it both ways now. You've got to either be on the side of we want to decrease abortion, so we're going to educate people and we're going to provide contraception that's free, or we're going to be so draconian, we want people to be dumb. We don't want them to have access to contraception, and we do not want them to have access to abortion. So right now we have a choice, and it's which choice are we going to make?
Well, I have to say that as I get to talk to the press, and I did with the National Public Radio in Logan talk on Monday. They had interviewed Lisenby and Birkland, who had written the cease and desist letters to the providers and lawyers and pretended to be the cops and pretend that the injunction really didn't matter because they knew more. And what they had said in their part of the discussion was that they needed to make adoption more reasonably cost and not as hard to do and things like that. And I said, and we also need to publicly talk about family planning. We need to talk about contraception. We need to make sure it's affordable. And what I point out to the press constantly, excuse me, is that for 3 years, Derek Kitchen brought to the legislature expanding Medicaid for family planning up to 200% of poverty. And for 3 years, they wouldn't even hear the bill. And then last year, Rosemary Lesser provided a bill that would have done more with postpartum care for women for mental and physical health once they've had the baby. And they chose not to do it. And they chose again not to do it this summer when it was brought up at interim. I agree with Lori. You can't have it both ways. As a state, you can't take away a bodily autonomy and not provide assistance for family planning. It just doesn't work. And we've all got to be singing that song together so that people, I don't care, use guilt, use intimidation, whatever needs to be done. But people have to realize there's a cause and effect.
There are some national commentators and national groups that have been anti-abortion that have taken principled positions that we should be providing more benefits to women and families. Apparently, not a lot of them are in our legislature. Are there any people locally, or are there any bills locally that you know of that might bring these two sides together on this occasion? You can be in favor of women's rights to choose and in favor of adequately supporting women who are making the choice not to have a child because of economic reasons and might make the choice to have a child if the economic circumstances were different. Are there any legislators or any people that are looking to bridge that gap?
We have a reproductive roundtable that is made up of the family planning physicians, uh, Planned Parenthood, the YWCA, A Better Utah, the ACLU, who work with legislators from all our different points of view. And it's nice having the YWCA and the family physicians who have different relationships than I would say I do with the legislators. And we are working to bring, though Derek Kitchen will no longer be in the legislature, we're looking for people, both Republican and Democrat, who could run that bill, at least for awareness. Rosemary Lesser, I don't know if everything has been counted. I'm hoping she's back. Okay. We're working with the maternal mental health groups and the Utah Department of Health can help with that.
Consider the Coalition of Religious Communities, which is focused primarily on homelessness and housing, but is represented by a wide range of religious communities, from liberal to conservative, that might also be interested in partnering on something like that.
Yeah, I mean, it's not a partisan issue particularly. I mean, it's far more of a consensus issue to think that people shouldn't get pregnant when they don't want to get pregnant, and that they should have the ability not to do that. And so that pushing that kind of a position, I mean, that's part of the reproductive justice movement with Sister Song. And I mean, their view is very much, look, let's get past the pro-choice, anti-choice rhetoric. Let's look at what justice requires. And that's, if you want to go one way or if you want to go the other way, and you get supported either way.
I'm thinking we have time for just one more question.
I'm thinking we have time for just one more question. Is anyone online still there? Want to type in a question? Anyone in the room?
While we're soliciting, I would just say with religious groups, we have had a number of religious groups approach us and look at their religion believes in a right to choice. There is even a lawsuit in one state, and I actually think it's California, with Judaism saying that their religion believes that you need a right to choice as part of the religion. Florida, yeah,
So
that it's in laws, excuse me, in the court in Florida.
So I have a question from online because apparently didn't interpret the question as well as I should have last time. So here's the question, word for word. This is a question about freedom of conscience. Specifically, I want to understand how the other side would argue it. How would they argue that outlawing abortion from conception can be applied to everyone without violating the freedom of conscience of people who do not believe human life starts from conception?
I couldn't argue that.
Let me ask
Well, they've got to argue that there's some conscientious beliefs that are wrong.
So-
That's the argument I think you need to make, that, or you can make an argument, and this is why I put the initial liberty is not absolute. Conscience is not going to be absolute. I mean, if I think I have a conscientious reason for killing an evil person, the state is going to say it's got a compelling state interest in preventing murder. And so, I think an argument that they would make it, again, I'm just playing lawyer, and what they might say, they might argue that that there's a compelling state interest that restricts certain forms of exercise of conscience, just as I couldn't, as a free exercise of religion, engage in human sacrifice.
So let me add to that just a bit. As I've read the literature, I'm understanding there's no medical benefit to prohibiting abortion, early abortion. Abortion's safer than having a baby. And unless you give the fetus personhood,
Mhm.
this is a person, what rational basis is there for prohibiting a pregnant person from choosing to terminate a pregnancy,
I mean,
other than moral?
well, so the legislature can have a moral reason, and that's going to pass the rational basis test. There's a wonderful study, by the way, that it was headquartered at University of California at San Francisco. It's called the Turnaway Study, which looked at longitudinally at what happened to women who were just too late to get an abortion versus women who got abortions, and their subsequent health, mental health, and so on. And there's just nothing to the argument that women do worse. That the data are all that people do better.
I happened to be in the room with the person who wrote that study today, and she was giving prognosis for what is going to happen now that we have Dobbs. And her feeling is that 50% of the people who can get pregnant in this country will not have equal access to bodily autonomy. And she, from her study and knowing the mental, physical, emotional health of women who were turned away, and looking at their next child or their family, it's not a good picture of what we will of the families that we will be making.
And most of those people did not choose adoption. Most of those people chose to keep their children because
10% choose
adoption.
adoption.
And just something else to be aware of here, when Linda introduced me, I write about data in public health, and data are really important to know what's happening. And my argument is that we need the data, and because we need the data, we need to protect it. And something that's also really frightening to me is that we may not be in a world in which we have good health data, either because people are managing things privately or because people are too scared about where information might migrate. So I'm frankly worried about the impact on our public health system. I mean,
And I'm worried about the children that will, unwanted children that will grow up.
yeah, but we need to know how many women are dying from botched abortions. We need to know how many women end up in severe prenatal postnatal depression. We need to know what's happening to children. And I'm worried that it'll be another problematic blow that way too.
Any final statements?
I wish I could think of something fun to say. It's never boring working in reproductive health. And if anybody wants a side job, we take volunteers all the time. And you can really feel good at the end of the day knowing you've helped someone have good sex.
Thank you very much. Thank you, speakers. Thank you, members. Thank you, guests, both in person and online. For anyone who found tonight's event useful, take a few minutes to like or share our related posts on Facebook, Twitter, Instagram. Is Twitter still a thing? I'm not sure. Yes. I want to give everyone, particularly league members, some heads up about next things. Unit meetings, Monday, the 28th at 7:30 in Holiday Library and on Zoom. The Night Owls unit will meet. The Central Wasatch Commission will be doing a presentation. Tuesday, November 29th at 11 on Zoom, the Summit Wasatch County unit will have a discussion with Katie Owens-Hubler, an expert in election administration, who we heard from, entitled The Midterm Election from County Clerk's Viewpoint, the Process and Results in Utah and Across the Country. Tuesday, November 29th at 6 p.m., the League of Women Voters Utah will present a webinar about the Dignity Index and how the index was applied with 2022 Utah candidates for federal election. December 5th and 14th, there are naturalization ceremonies. I think volunteers are still sought. December 7th is the holiday social and fundraiser. League members and guests, please join us for our holiday social potluck at 6:30 to 8:30. You can get the details and RSVP on the website, lwvsl.org, or talk with Shauna or Linda Sage after tonight's meeting. Thursday, January 5th at 11 o'clock, the town club meets. The topic will be lobbying in Utah, and Ashley Spatafore Mirabelli will be presenting. Find more information online. And finally, our next general meeting will be Saturday, January 7th at 10 a.m. here and online, the annual legislative forum presented jointly with the American Association of University Women regarding what is expected in the 2023 Utah General Session. Maybe we can give them some ideas if they don't already have them. So thank you very much.